Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Live Law, your one-step destination to all legal developments in the country. Let us start. Starting with an important judgment that was delivered by the Supreme Court today, that is on the batch of petitions seeking 100% verification of electronic voting machine data with VVPAT. The petitioners prayed that instead of the prevalent procedure where the Election Commission cross-verifies EVM votes with VVPATs in only 5 randomly selected polling stations in each assembly constituency, all VVPATs be verified. They further sought measures to ensure that a vote is recorded as cast and counted as recorded. The bench of Justices Sanjeev Khanna and Dipankar Datta have rejected the pleas. Though the cases were reserved for orders on 18th April, they were listed again on 24th April as the bench wanted some technical clarifications from the Election Commission. Taking into consideration the answers given, the orders were pronounced today. The prayers for reverting to ballot paper voting, complete EVM-VVPAT verification, giving VVPAT slips to voters, and regarding the conduct of election rules have been rejected. However, 2 directions were issued. First, after symbols are loaded into the VVPAT starting from 1st May 2024, the symbol loading unit will be sealed and placed in secure containers. The candidates or their representatives will sign the seal. These containers will be stored in strong rooms with the EVMs for at least 45 days after the election results are announced. Afterwards, they will be opened, inspected and handled like the EVMs. Second, that after election results are announced, the memory controllers with issues in 5% of the EVMs, control unit, ballot unit and VVPAT for each assembly segment of a parliamentary constituency will be inspected for tampering. This check, performed by engineers from the EVM manufacturers, will only occur if candidates who are placed second or third after the highest polled candidate makes a request in writing within 7 days of the results being declared. These candidates or their representatives must specify the EVMs to be checked by polling station or serial number. All candidates can be present during the verification. Besides these, the bench suggested to Election Commission to see if there can be an electronic machine for counting the VVPAT paper slips and whether along with the symbol there can be a barcode for each party. On 29th March, the Delhi High Court is set to hear the petition seeking to disqualify Prime Minister Narendra Modi for allegedly seeking votes for the BJP in the name of Hindu as well as Sikh deities and places of worship. The plea has been moved by a lawyer. The petitioner was aggrieved by the Prime Minister Modi's speech delivered on 9th April in Uttar Pradesh. He seeks the direction on the Election Commission of India to disqualify the Prime Minister from elections for the 6 years under Representation of People's Act. A further direction is sought to restrain him from seeking votes in the name of religious deities and places of worship. He also states that he filed a complaint earlier this month before the Election Commission of India, but till date no action had been taken. Justice Sachin Datta, who had to hear the matter, was not holding court today as he was sitting in UAPA tribunal. So the matter will now be taken up on 29th April. Stay tuned. The Supreme Court today issued notice on a petition seeking a direction that election must be declared as null and void if maximum votes from a constituency are polled for NOTA, that is none of the above, and a fresh election should be held for the constituency. NOTA was introduced in the EVMs following a direction issued by the Supreme Court in 2013 in a PIL filed by the People's Union for Civil Liberties. NOTA gives the option to the voter to reject all candidates as unsatisfactory. However, as per the existing law, there is no legal consequence if NOTA gets the majority of the votes. In such an eventuality, the next candidate will be declared as the winner. The petitioner here has sought a direction that the same candidate who lost to NOTA should be barred from contesting the by-election which is held after the cancellation of the first election where NOTA got majority votes. Further, there should be proper publicity for NOTA as a fictional candidate. The petitioner has sought directions to the Election Commission of India to frame appropriate rules in this regard. Senior Advocate Gopal Sankara Narayan, appearing for the petitioner Shiv Kheda, cited the recent example of Surat constituency, where the Bharatiya Janata Party candidate was declared the winner without any election, as the nomination of the Congress candidate got rejected and the other candidates withdrew their nominations. Even if there is only one candidate, there should be an election, as the voters should have the option to vote for NOTA. Do let us know your views on this in the comment box below. A Delhi court has today dismissed an application moved by BJP MP and former Wrestling Federation of India President Brij Bhushan Singh, seeking further investigation in the sexual harassment case filed against him by the women wrestlers. Singh had sought a direction on the Delhi police to investigate regarding his presence at the Wrestling Federation of India office on 7th September 2022. This is the alleged date of the incident. He had claimed that on this date he was not in India. The Delhi police and the complainants had objected to his application, saying that the application was a delaying tactic. Last week, the court had deferred the order on Singh's application. Today, the court dismissed the application. Further, Additional Chief Metropolitan Magistrate Priyanka Rajput of Rouse Avenue Courts will now pronounce the order on framing of charges in the case on 7th May. The next update is on the Muzaffarnagar student slapping case. This, you already know, is regarding an incident where a teacher at a school in Muzaffarnagar allegedly asked her students to slap a student and allegedly uttered communal slurs against him. Following the incident, a public interest litigation was filed seeking a proper and time-bound investigation into the incident. Previously, the Supreme Court had asked the state of Uttar Pradesh about the steps taken to prosecute the offender. Today, the counsel appearing for the state informed the court that the statements of around 18 witnesses had been recorded during the investigation. That notice had been issued to the accused and her statement had also been recorded. The court was informed that the charge sheet against the offender is ready and only sanction from the concerned authority is awaited. Today, the court also heard an application filed by the father of the victim child in this case. It included prayers for reimbursement of the child's tuition fees and for providing stationery, school uniform and similar things. Though Additional Advocate General Garima Prasad submitted that the books had been given and the state had written to the school as well as the other NGOs, the statement was opposed by the petitioner's counsel, Advocate Shahadan Farasat. The court has now ordered the state to file an affidavit in this regard to the compliance of these prayers and has posted the matter 2 weeks later. The Supreme Court today declined to interfere with the Madhya Pradesh High Court's order upholding the rule that stipulated eligibility of at least 3 years of practice or 70% marks in law graduation for entry-level judicial service candidates in the state. In the year 2023, an amendment in Rule 7 of the Madhya Pradesh Judicial Service Recruitment and Conditions of Service Rules of 1994 was made. Through this amendment, an additional eligibility qualification for the post of Civil Judge Junior Division entry level was introduced. As per this amendment, all those who had practiced continuously as an advocate for not less than 3 years on the last date fixed for submission of application were eligible to apply. Also, in the alternative, an outstanding law graduate with a brilliant academic career having passed all exams on the first attempt by securing at least 70% marks in the aggregate was eligible to apply. Before the High Court, the present petitioner sought to set aside this amendment and argued that it was ultra-vires to the Constitution of India. The High Court had observed that the amendment does not deny opportunity and that the object of the amendment was a qualitative dispensation of justice, and excellence should always have precedence over mediocrity. Now, the bench of Justices Rishikesh Roy and Prashant Kumar Mishra of the Supreme Court has opined that there was no reason to interfere with the High Court's view and has dismissed the SLP filed against the High Court's order. Lastly, an update on the petition filed by Delhi Chief Minister Arvind Kejriwal challenging his arrest by the Enforcement Directorate in connection with the Delhi liquor policy case. Earlier this month, the top court had issued notice to the Enforcement Directorate in the petition. Seeking ED's response, the court had posted the matter in the week commencing on 29th April. Today, Kejriwal's counsel, Senior Advocate Abhishek Manu Singhvi, mentioned this matter before the bench of Justices Sanjeev Khanna, Dipankar Datta and Prasanna B. Varale. He said that the petition was being shown to be listed on 6th May. The bench agreed to consider the request and asked Singhvi to move an email in this regard. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.